Well, hi everyone, Sean Humphreys here. Welcome to this video presentation we put together. It's a video presentation that came out of a luncheon that we sponsored for our clients. And it was a follow-up to a series of videos and presentations dealing with general topics around estate planning. So we had will and estate planning, discussion on powers of attorney, and then this discussion on healthcare directives, sometimes referred to as living wills as an example. Really important document, and I think a lot of times we think of these documents in the context of, elderly individuals, but car accidents, strokes, unfortunate events can come up for all of us. And so the healthcare directive is your ability, it gives you the ability to articulate before those events happen what your wishes would be from a healthcare standpoint. So Cynthia Hebert-Simkin, a local lawyer in Winnipeg, did the presentation. She did a really excellent job of going through the nuts and bolts of the document. And as you look at your own wealth planning, we often focus on tax planning, investment planning, retirement planning, but the whole area of healthcare directives is a part of that overall plan. And when clients go through the exercise, they experience peace of mind and additional confidence that their overall plan is well looked after. And so I'd encourage you to go through the presentation. It's fairly lengthy, but if you're trying to get up to speed on the topic, then you'll find it helpful. We also have a resource that is part of this presentation. It's a document that's been put together to help clients work through some of the key issues around healthcare directives as well. So I hope you enjoy the presentation. At the end of the presentation, we'll talk about our wealth planning process. And so if you are someone who's looking for clarity on your overall planning, this is one aspect of it, then you should take advantage of our process called Game Plan and identifying the gap process. And so that information is at the end of this presentation. So all the best in your wealth planning journey. Package, you'll have this advanced healthcare document. This is a resource for you. So I'm going to introduce Cynthia right away, our guest speaker. But I would encourage you to take a look at this document after the session today. It has a lot of questions that kind of walk you through some of the key issues. Most of you, if you saw the invitation I sent out, and I gave you a few questions to ponder, those questions actually came from this particular planning document. This is not an exciting or uplifting topic to be focused in on. So all of you should be commended for taking the time to get your head wrapped around healthcare directives and the implications around that, sort of end-of-life planning. And the reason that we want to focus on these topics is that when we focus on retirement planning or investments, how much did I make this year? Hopefully I didn't lose any money this year. How do I save taxes? Those are really important topics, but the topics that provide additional peace of mind. We're laying awake at night thinking about our planning. As time goes on, we begin to think about whether it's our estate planning, or will planning, powers of attorney, healthcare directives. Really important area. Not necessarily a lot of fun to come to grips with when we're sort of immersed in it and thinking about it. And there's lots of inertia that sometimes keeps us from really looking at this area. But once you attack the area, have a plan in place, huge peace of mind, right? And peace of mind is worth an awful lot. So again, you're to be commended for coming to the session today. Well, it's a real pleasure for me to have a chance to introduce our speaker. I'm not going to go through this bio in a lot of detail. How many of you had a chance to hear Cynthia previous and other presentations? Great, so a number of you. So Cynthia was our guest presenter last month, and she's also spoken at branch events. Those events are a lot different. If any of you have attended them, they're usually 300 people in the room, and we'll pick a topic. These are more intimate settings. But Cynthia has a depth and breadth of expertise as a lawyer, and she's worked in many areas of law. In fact, I think your initial area was family law, correct? And so lots of interesting experiences. I think probably Cynthia could write more than one book about her family law experiences. And so her specialty, though, is really estate planning. So estate planning, powers of attorney, healthcare directives, just giving family clarity in that area, and also estate administration. So one of the things that her team does is to give executors and powers of attorney direction on how to fulfill their responsibilities appropriately. We mentioned this last time. One of the fastest areas of litigation in this country today is litigation against executors and powers of attorney. So either those folks defending themselves against litigation, or families litigating people with that responsibility. And why do you think it's growing so quickly? How many times do you act as a power of attorney or an executor in your lifetime? Maybe once if you're anointed, maybe. How much training do you get? 0. So a lot of people are making it up along the way and unintentionally making mistakes. So folks like Cynthia in her legal capacity play a really important role, either coaching powers of attorney executors to make sure they do the role effectively and properly, or actually playing that role on behalf of clients so they don't get litigated. So I want you to join with me in giving Cynthia a very warm welcome. Cynthia, thanks for coming today.
Thank you very much, Sean. I have to say that everything I was going to say about my firm, he's already said, so I don't have to say anything. I just wanted to put our topic today into perspective when we're talking about an estate plan. When somebody comes to see me to do documents, usually what they say is, I want a will. And that's understandable because that's often top of mind. I want to be able to plan for what's going to happen in the event that I pass away, or rather when I pass away. And what I always talk to the clients about is the estate plan as a package of documents, and there's the will that takes effect from the moment of death. But even more importantly, from a day-to-day perspective, is the power of attorney, because this is helping to manage our affairs in the event that we need that kind of help. And then, of course, the healthcare directive, which deals with medical decisions. The healthcare directive has nothing to do with money. It has everything to do with decision making. And it's a very important piece of it, because if we lose the capacity to manage our own financial affairs, we may also lose the capacity to make our own medical decisions. And we have to be thinking about who would make those medical decisions in the event that we're unable to do so. So today we're going to do, we're going to try to cover 4 topics. The first topic is the healthcare directive. Then is what happens if I don't have a healthcare directive, because not everybody does. Then we're going to do a brief review of the medical assistance in dying legislation that was passed by the federal government last year. And then we're also going to do a brief review of what about the body after I'm gone? Who has the rights to the body? Because we've all heard about people fighting about funeral arrangements, fighting about where somebody's going to be laid to rest. So what exactly does that involve from a legal perspective? But first off, let's talk about healthcare directives. In Manitoba, we have a piece of legislation that's called the Healthcare Directives Act. But most people think about these documents by the term a living will. It's a document that can help guide the people who have to make medical decisions in the event that we cannot make it for ourselves. And the person who makes that medical decision for you in our legislation is called a proxy. So the proxy is the person that you appoint to make medical decisions in the event that you can't. The legislation around this kind of document is provincial. So if you prepare a document in Manitoba and then you move to another province, your document should be reviewed by a lawyer in that province to make sure that it complies with the legislation there. I always tell my clients that if they're going on a trip, you want to take your healthcare directive with you in the event there's any kind of medical emergency. It might not have the same force and effect in Manitoba, but it's certainly an indication of what you wanted to have happen in the event that you couldn't make a medical decision for yourself. And the document can also specify treatment options. In my practice, we usually have 2 options. One is called a simple healthcare directive, and the other is an advanced healthcare directive. And when we're retained, we send out copies of both, and we say to people, take a look at this and think about what you'd like to do. Which document would you like to have? And the simple healthcare directive is a 1-page document. It appoints a proxy and an alternate proxy in the event that the first name proxy can't act. And it has some general language that essentially means, don't keep me alive on machines. That's an almost universal wish. I have met very few people who have said that in the event that I can't make a medical decision and I'm being kept alive on machines, please do continue to do so. It is almost universal that we do not want to be kept alive by artificial means. And then there's a little bit of language about what a reasonable expectation of recovery might mean. And then as a precaution, I always ask my clients if they want to be organ donors. And we put in a little paragraph about organ donation if they'd like to do that. The Advanced Healthcare Directive has more specific treatment options. It will have a section in my office, it has a section on reversible conditions and irreversible conditions. So the section on reversible conditions is what happens if I have something that is easily treated? What kind of treatment do I then want? And if I have an irreversible condition, if I've now been diagnosed with something that is going to kill me, and what kind of treatment options do I want then? The important thing to keep in mind is that when doing that kind of document, that Advanced Healthcare Directive with more specific treatment options, is that your wishes may change as your medical conditions change about what it is that you think would be appropriate. For example, if I have a heart attack today, I want everything. I want the paddles, I want CPR, I want adrenaline, I want everything. If I've had 4 heart attacks, my opinion might change. I might at that point say, I have now outlived probably my natural lifespan 100 years ago, and if I have another heart attack, then I'm okay. Now I don't want everything. So if you do an Advanced Healthcare Directive, it's important to double check it every once in a while to make sure those treatment wishes are still valid. Also, when doing an Advanced Healthcare Directive, I am not a doctor. And so I'm not in a position to say this is exactly what all of these treatment options are. And so it's wise to consult with your physician or a medical staff of some kind in order to get information about what the various treatment options mean. The document has to be in writing, it has to be signed, it has to be dated, but in our legislation there is no particular form. There's no document that's attached as a regulation form to the legislation to say this is the healthcare directive. So it can pretty much be almost anything, as long as you're providing direction. One of the things that's unfortunate is when somebody has done a living will that they pulled off the internet, and it may meet all of their treatment wishes, but they have not set out who is going to be their proxy. They haven't named the person who is going to make a medical decision for them. So that's something to be aware of if you're preparing the document on your own. The person who's making it has to be over 16 years of age, and they also have to be mentally capable to give an informed consent to medical treatment. So this is the capacity that you need to sign the document that is then giving authority to someone else to make the medical decision if you cannot. When you have a healthcare directive, it is binding on the healthcare providers as soon as they have notice of it. But if they don't know about it, then it's not binding on them. So that's why it's very important that we provide copies of our healthcare directives if we're going into the hospital for any kind of treatment, whether it's day surgery or more intensive surgery. We want to provide a copy to our proxies so that in the event that something happens, they've got it available, readily available, and that they can take it to the hospital and say, I have the authority. We also, in our office, if people have the one-page simple healthcare directive, we've managed to figure out a way to reduce it so it's about a quarter of the page. And what I tell my clients is write the phone numbers of your proxies on it, fold it up, tuck it in with your Manitoba health card in your wallet. Because if there's an emergency, the hospital is looking for that Manitoba health card. They want to be able to look online. They want to see what your medications you're taking. They want to get a sense of what your medical history is. And so then they have notice of it. And we found that it's perfectly legible. So you want to make sure that you provide the healthcare directive in those situations where you are going to be requiring any kind of medical treatment. And what you also should be doing is including a copy if you have an ERIC. How many people have an ERIC, right? Emergency Response Information Kit. So this is a kit that has a couple of magnets on the back and it goes on the fridge. And in the kit, There's a document that's provided that has a list of medications, Manitoba health card number, all kinds of information that in an emergency that they would need. The kit also provides a little stamp. It's got a little, sorry, I'm just playing with the package here. This goes on your door so that if the ambulance attendants are there, they know to look for the kit. It also has a sample of a simple healthcare directive that has been prepared by the province of Manitoba. So if nothing else, you could take a look at that and prepare a simple healthcare directive. And then what you do is you put it on the fridge, and they're trained that if they know there's an Eric, they go to the fridge, they slap it on your chest as they're carrying you out the door, and then the information is readily available at the hospital for what some of the treatment options are and then they will know. You put a copy of your healthcare directive in here, and then they know who they're supposed to be contacting. And again, I recommend to my clients that they write the phone numbers on there so that it's easy for the hospital to contact the people to let them know there's an emergency and they need to come down. If you don't have one of these, they're available at seniors directorates throughout the city, and you can look online for where to get one, ERIK. I'm told they're also available at fire stations. So if you've got a fire station in your neighborhood or you're passing one on the way home, you might want to stop in. And what I've started doing is, they think they're like $1.50 or $2.50 or something for me to buy them. And I buy them every once in a while, and I've started giving them to my clients. I'll ask my clients, do you have an Eric? And if you do not, I will provide it to them. And I've been trying to figure out what is the appropriate age to let them know that I think they should have it. I've decided 70 and up. That's all. I'm just doing 70 and up. That's my line. I'm not saying you're a senior. I just think it might be wise to have this on your fridge. So as long as you're able to make medical decisions for yourself, absolutely you are making your own medical decisions. And nobody's going to be stepping in and saying that they should do it. The circumstances where you may lose the ability to make the medical decision will vary depending on what is happening with you. If you are not competent, so you're suffering from a cognitive impairment of some kind, you're suffering from a dementia of some kind, then your healthcare proxy will be making the decisions. If you are unconscious, or you're suffering from incompetence as a result of a drug interaction, then the proxy will be making a decision for you, but you may regain your competence, and then you will make decisions for yourself. Or if you are unable to communicate your decisions, once you regain the ability to communicate, you will then be able to make your own decisions again. But as long as you are not able to communicate your decisions, then the proxy will be making the decision for you. So with a healthcare directive and making medical decisions, it can be a sort of floating, can make a decision, cannot, depending on what's happening. If I have a car accident on the way back to the office, and I'm taken to the hospital unconscious, I cannot make a medical decision. So my husband is appointed as the first name proxy, and he would. I come out of being unconscious, I awake, I'm then able to make decisions, I go into surgery, I have a reaction, I'm now in a coma, I cannot make decisions, I come out of the coma, I can make decisions. I have a stroke, maybe I can't communicate, I cannot make decisions. I recover from the stroke, I can make decisions. So you can see where it can depend on exactly what is happening. But the capacity, again, for this kind of documents is whether or not you have the ability to make an informed decision about your medical treatment, to be told and understand what your medical situation is, and come up with an appropriate response to whether you want the treatment or not. Because an important part of informed consent is that we are entitled to decline treatment. So who then should you be appointing as your proxy? According to the legislation, your proxy has to be over the age of 18. And in general, when speaking with my younger clients about this, I recommend that young adults between the ages of 18 and 25 not be given a lot of power or authority to make decisions either as executor of a will, either as an attorney under a power of attorney, or as a healthcare proxy. Simply because my work with young adults in the past has shown that they may lack the emotional maturity to handle the business-like aspects of those jobs while still confronting their own personal emotions about what is going on. Some young adults are remarkably mature, and they may be able to handle it. It's a decision for people to make. But with my younger clients who have, young adult children who are 21 or 22, the hope, of course, is always that the children are not going to have to make those decisions until they're in their 40s or 50s. That's the hope. We plan for the best, we plan for the worst, and we hope for the best. So that person has to be able to confront the reality of making a medical decision for you. And this needs to be a person first they have to be 18, but from a non-legal perspective, they need to have the emotional maturity to be able to handle the worst decision of all. The worst decision of all, of course, is that circumstance where they're standing in the hallway with the doctor while the machine's beeping in your room, and the doctor is saying there's no hope of recovery. And now what are we going to do? So whoever you choose as a proxy needs to be able to deal with that situation on an emotionally mature basis. And it's a horrible, horrible place to be. It is an awful place to be. But that's the kind of emotional maturity that they're going to need. You should always, in appointing anybody to any of these jobs, make sure that you've talked to them. I actually did have a case recently where somebody was appointed as the executor and didn't know until the person passed away. It was a big surprise. What? So you want to talk to them, want to make sure that they're comfortable in taking on these roles. And you also need to talk to them about what it is that you would like to do. So if you have particular wishes about the kinds of treatment that you want, you need to talk to your healthcare proxy and make sure they understand what those wishes are. According to the legislation, if the proxy knows what you would want to do, then they are obligated to follow it. If they don't know what you would want to have done in a specific situation, then they are going to be guided by past conversations that you've had and their best guess about what you might want to have happen. So that's why you want to have as specific a conversation as possible about some of these, about some of the treatment decisions that you might want. We talked earlier about consulting with medical professionals in the event that you're doing an advanced healthcare directive so that you understand what all of the treatment options are and what they mean. I have to say that in my practice, most of my clients want the simple healthcare directive. They want to be able to talk to their proxy, they want to be able to tell them what their wishes are, they want to have a proxy appointed. But then after that, they're generally fine with leaving it up to the proxy to make the appropriate decision at the time, depending on what the circumstance is. Because we can't possibly guess in advance every circumstance that's going to arise. And the one last thing on healthcare directives is that if you have a current healthcare directive and then you change it, it's important to make sure that all of the old copies of the healthcare directive that are out there, maybe your doctor, maybe the proxies, all of those things, you need to get those back in, and you need to provide the proxies and physicians and your all the appropriate people with new documents so that somebody doesn't have an old one and think they have authority when someone else has now been appointed to act as a proxy. So that's what happens if you've actually prepared the document, but there are many circumstances where people don't. So what then happens? It used to be sort of up for grabs. I would have people calling me and saying, well, my mother's in the hospital and they're telling me that I'm the executor and therefore I should make the medical decision. And then I'm on the phone with my client saying, well, as executor, you have the ability to make decisions once your mother dies. Until your mother dies, the will does not come into effect. You have no authority whatsoever under the will. Or somebody would phone and say, well, I'm the attorney for my dad, and the hospital is telling me that I get to make the decisions because I'm the attorney. Unless that power of attorney has incorporated a healthcare directive paragraph that says the attorney has the ability to make healthcare decisions, then no, the attorney would not have the authority to make it. Sometimes you'll see that. Sometimes you'll see powers of attorney that will have a paragraph in it that say that I'm making this is a healthcare directive and I give, my attorney the authority to make healthcare decisions. My preference is to do two documents, separate documents, because first off, if it's an emergency and somebody's looking at the healthcare directive, I don't want them going through the 5 pages of the power of attorney to try to find out if it's there. And secondly, quite frankly, it's none of the hospital's business what I'm doing with my money. The hospital's concern is medical decisions. So that's why I prefer to do a power of attorney and a separate healthcare directive. But in 2011, the Winnipeg Regional Health Authority and the Manitoba College of Physicians and Surgeons came up with a policy. This was April of 2011. It's called Advanced Care Planning Goals of Care. And it's about 5 or 6 pages long. It's available on the internet, and it's actually a very important document to have if you are a caregiver for an older adult, because it sets out how in the Winnipeg Regional Health Authority system decisions are made. Who is it that they're going to for decisions? What's the consultation process? And it sets out what happens if you have a disagreement with the doctor and the whole process of what can happen. So it's an important document for anybody who's dealing with the WRHA to have if they're making decisions for somebody who is an older adult. And in the definition section of this policy, it sets out in order of priority of who can be, for their purposes, a substitute decision maker. That's the definition that they've used in the policy, a substitute decision maker. So first off, they're looking, does the person have a healthcare directive? If they have a healthcare directive, then yes, that's the first person who's in line to make a decision to be the substitute decision maker. Then they're looking to see if there's a committeeship order. Now, a committeeship order is an order from Court of Queen's Bench if somebody was now incompetent to manage their own affairs and did not sign a power of attorney. So there's a process that you go through in order to get a committeeship order. It's spelled committee, but it's called committee. Don't ask me why, or it's pronounced committee, I don't know why. But then they're looking to see the committeeship order. But the committeeship order has to have a specific section that says the person has the authority to make personal care decisions, because there's 2 kinds of committeeship orders that you can get. Most people, when they're applying, will get the committeeship order that covers property and personal care. Then they're good to go. Some people may only have the committeeship order that allows property, and then they don't have the ability to make medical decisions. So you have to look at the order itself to see if there's the authority to make the medical decision. And then after that, we're now looking at basically a family tree. If you have no healthcare directive, there's no committeeship order, or there's no order under the Vulnerable Persons Act. The Vulnerable Persons Act is a piece of legislation that will cover most adults who suffered from some form of illness or injury prior to the age of 18. So if somebody suffers a head trauma, for example, before the age of 18 and they have difficulty managing their own affairs, they would be covered by the Vulnerable Persons Act, and there can be an order under the Vulnerable Persons Act. If somebody had a developmental issue, if they had Down syndrome, or if they were severely autistic, or if they had some other issue that meant that they needed help in day-to-day living, then they may well be covered by the Vulnerable Persons Act as long as the condition arose before age 18. So if there's none of those things, then it goes to parents or the legal guardian if there's a minor. Then it's spouse or common law partner, then son or daughter, parent, brother or sister, person with whom the individual is known to have a close relationship, the grandparent, grandchild, aunt or uncle, nephew or niece. So it's interesting, that language, the person with whom the individual is known to have a close personal relationship. So if I have no spouse, no children, my parents are gone, and my siblings aren't here, and I need somebody to make a medical decision for me, and I have a girlfriend that I've known for 50 years that I have coffee with 3 times a week, she might be a person with whom I have a close personal relationship, and she may be able to do that. And this is very important because there are some older adults in our community who have nobody, and that the person that's closest to them is going to be somebody who is not related by blood at all. So for the purposes of this policy, capacity is defined as being able to understand the information that is relevant to making a decision and able to appreciate the reasonably foreseeable consequences of a decision or lack of decision. And that's essentially a definition of the ability to make informed consent decisions with respect to your care. Now, if you live outside of Winnipeg, and you're now dealing with a regional health authority outside of the WRHA, you have to check the website for the regional health authority that covers your particular situation, and then determine whether or not, if they have a policy. I was trying to find one for the area of town that my mother and father live in. I'm not sure there is one. So that then covers the ability to make medical decisions in the event that you cannot make it for yourself. The next topic that I wanted to cover just very briefly is medical assistance in dying. And what I'm proposing to do is just to cover some of the high points of it, and if you wanted specific information about the conditions that are required or what the kind of factors have to come into play before, they call it a MAID, medical assistance in dying, before the medical assistance in dying can kick in, then in the questions section afterwards, ask me and I'll set that out. But I don't want to get bogged down too much in those details right now. The medical assistance in dying legislation was passed by the federal government in June of 2016. And there was a gap period of a number of months while the legislation was in effect federally, but the province hadn't passed their guidelines or quite figured out their protocol in order to deal with it. And so in that gap period, it was necessary to make a court application to have a Queen's Bench judge look at all of the information about why it would be an appropriate situation for medical assistance in dying, and then the court order would be made. That should no longer be the case because the protocols are now in effect, and if you Google Manitoba medical assistance in dying, you'll be taken to the page which sets out the criteria in Manitoba. There is a provincial government website for the Department of Health, Seniors and Active Living. I always find it interesting that those three are grouped together. But essentially, the authorized healthcare provider would then provide or administer medication that brings about the patient's death at the request of the patient, and it's only available where the patient meets the criteria which is set out in the federal legislation. Somebody has to meet all of the conditions to qualify. They can't meet all but one. They have to meet all of the conditions. And there's also a definition of what kind of medical condition is necessary in order to qualify. But if someone does want to access medical assistance in dying, then what they do is they speak with their healthcare provider. And there's also a provincial service team, and there's also contact information on the website.
Well, I hope you're enjoying this presentation on healthcare directives. I think Cynthia's doing a great job of going through the key issues in this very important topic area. If you're enjoying this presentation, I think you'd really enjoy visiting our YouTube channel, All Things Retirement. And on that channel, there are videos on retirement income planning topics, estate planning, tax planning, and various other topics that I think are relevant to overall wealth planning. So be sure to take a look at that YouTube channel, and as well, if you go to our website at seanhumphreys.com, there's additional topic and information that you can download on a number of topic areas if you want to improve your situation financially.
There's two different types of medical assistance in dying. One is where the medical provider administers the medication or drug, which is commonly known as voluntary euthanasia. And there's also the provision where the person can be prescribed a drug which they then take on their own, which is then known as medically assisted suicide. One of the important things to know, and this is sometimes a surprise to people, is that under the legislation, medical assistance in dying is not available to someone who has dementia. So if someone has an advanced case of Alzheimer's, medical assistance in dying is not available. And the reason that it is not available is that you cannot consent in advance to make a request for dying. You have to have the capacity to make that decision at the time, having met all of the conditions, and so that people who have illnesses that erode competence, like Alzheimer's, Lewy bodies, Huntington's, any of the cognitive impairment illnesses, would not be able to use medically assistance in dying because they don't have the capacity at the time when their health may warrant it. And the reason that this was done was an overriding concern of the extreme vulnerability of someone who has an incompetence as a result of an illness, that they are extremely vulnerable, and because they cannot make the decision for themselves, someone should not be allowed to make the decision for them. I would like to presume that somebody in that circumstance making a decision for a loved one who had an advanced dementia illness would be making it from all of the right motives. But given what we now know about financial abuse of seniors, that's not necessarily a given. And that is the concern. And that is why it's not available to clients with any form of dementia. There was discussion at the time that the legislation was introduced that they were going to do more research on it, and they were going to look at the possibility. That was supposed to be done 180 days after June 2016. I don't think I've seen anything yet, so I'm not sure exactly where that is. Now, CTV News did an article at the end of December which showed that at least 744 people in Canada had used medical assistance in dying between June 17th, when it became law, and December 16th. And of those, 18 were in Manitoba. Most of the cases were in Ontario, understandably so, because Ontario has a huge chunk of our population. Of the Canadians who used it, most were suffering from cancer or neurological diseases, including multiple sclerosis or amyotrophic lateral sclerosis, so Lou Gehrig's disease. And there wasn't a lot of data available to CTV News when they did the report about who had been turned down or why they might have been turned down. Turns out Alberta has the best statistics on that, and it showed some patients were ineligible either because of a mental health diagnosis, so that they would not have had the capacity to make the decision, or because death was proven not to be imminent. So it made it be something that would eventually result from a current medical condition, but it was not imminent, which is one of the factors that's required. So now we're going to move on to a rather odd little topic, and I have to admit I did a little bit more research on this because it's not something that comes up a lot in my day-to-day practice, but what happens with our body after we go? Who has the right to own it? Because I'm not here. As long as I'm walking around, I own this on multiple levels. I own this, right? But what happens after I'm gone? And strictly speaking, no one can own a body. The executor, who has authority from the moment of my passing, has what's known as possessory rights. So they have obligations with respect to my body, but they do not own my body. It's up to the executor to make the funeral arrangements. And I, in fact, cannot make a binding arrangement about what I want to have done with my body. There's a wonderful little case I'm going to tell you about out of England. It's called Williams and Williams, and it was the 1880s, so over 120 years ago, and it's still good law today, which is why we still keep those dusty, musty old law books around, because it's still the leading case. It comes out of England. So in the 1880s, Henry Crookenden died, and he had left a memo with his friend Eliza about what he wanted to have happen with his body. And we don't know exactly what arrangement or what kind of friendship Henry and Eliza had, but she had this very important document. So after he died, she took the document to his wife and the executor to say, this is what Henry wanted. And the executor and the wife looked at it and said, no. And they made arrangements to bury him in the local cemetery. 2 years after his passing, Eliza, through various means of skullduggery, managed to get herself forged papers to exhume the body. 6 days before the wife was able to do anything about it, and Eliza had the remains hustled on board a ship and sent to Italy. And we know what kinds of things happened to preserve a body in 2017. It is doubtful the same kinds of things existed in 1880s, so this would not have necessarily been a very pleasant task, but she was determined to see his wishes given weight. So she took him off to Italy, and his instructions were that he was to be burned in a wood fire. Now, cremation was not very well known, nor was it popular in England at the time, and it may have been, we don't know, it may have been that that's why the executor and the wife said no. She then had the remains, the ashes, put into a Wedgwood earthenware vase that Henry had given her for that purpose. This is where I want my ashes to go. And then she buried the vase in consecrated ground, as Henry had wished. So when she returned to England, she went to the executor and wanted reimbursement for saying, I finally did what Henry actually wanted to be done, and it cost me £321, which in 1880 would have been an astronomical amount. It was a very large amount of money. The executor said no, and so Eliza sued. So the judge had the opportunity to take a look at the whole issue of, does somebody own the body? And what the court said was that you cannot make a binding arrangement to deal with your remains. You can dispose of your worldly goods, but you cannot dispose of your body. Why not? Because the corpse does not form part of your estate. So no one owns it. And that's where we say that the executor has the possessory rights and the obligation to bury the person in a dignified manner, but they do not actually own the body. So Eliza did not get her reimbursement. Well, what happens if you do have specific wishes and you have certain things that you want to have happen? My mother has been giving me bits and baubles over years. I want this hymn, I like this program, right? So she has some very specific wishes about what she wants to have done. So it's important that we tell the executor about what we want, so that the executor, when making the funeral arrangements, is then aware of what her wishes are, and could be either verbally or in writing. But it's still not binding on the executor. The executor can still decide to say no. Some people like to put those kinds of instructions in their will. And the will isn't really the best place to put it, because if you pass away, the will is not the first place somebody is looking for that kind of thing. And you don't want to have specific instructions in your will. The executor is unaware of it, makes other arrangements, and then discovers that they did something that was different than what you had wanted. So still, very important to make sure that your executor knows what you want to have done. It also may be that the executor cannot do what you want. What it said is that there's a common law duty for the executor to bury the deceased in a manner that is fit for his or her station in life. Now, station in life is very old language. It didn't mean any kind of graduated class system. What it meant was you needed to have, the executor needs to be able to spend on the funeral something that is common sense in relation to the size of the estate. So, for example, if you're rich, you can do whatever you want. There was a fellow named John Fuller who died in 1834. He was buried in a pyramid-shaped mausoleum, sitting in a chair with a glass of claret in his hand. What I don't know is whether or not anybody was obligated under the terms of the will to go in and refill the claret every once in a while. So a deceased who has more modest means can say, this is what I want, but ultimately it's up to the executor to take a look at what does that mean in relation to the overall value of the estate, and the executor might not be able to do it. But it's one of the reasons why a wise executor, especially where the executor isn't the spouse, because quite frankly the spouse can do anything that they want, right? They're ultimately going to pay for it personally. But if it's not the spouse, that's why the wise executor would be consulting with the people who are the beneficiaries to make sure that they're all on board with the plans that are being made, so that there is no issue about payment. Because if there is an issue, if the beneficiaries kick up a fuss about the amount that was spent, then the executor may have to personally pay back an amount because they spent too much. So the executor who overspends might not get it, might not be reimbursed. And the executor who doesn't know about a prearranged funeral plan will also be in trouble. So if you have a prearranged funeral plan, it's very important that you tell the executor about it so that they're not making arrangements at funeral home B when you in fact already have all the arrangements made at funeral home A. And that also puts the financial exercise on the other foot. So if the executor spends money on a funeral knowing that there is a prepaid plan over here but decides to do it over here, then the executor may be responsible for paying for that funeral that is not in compliance with the prepaid plan. The executor also is obligated to inform the next of kin of the funeral arrangements. And this does occasionally come up where people will phone and say, my father died and nobody told me. So the executor does have an obligation to inform the next of kin. But what happens if someone dies, they don't have a will? Then who's making the funeral arrangements and who has the obligation? Because the executor's authority arises from moment of death. If there is no will, then somebody has to apply for letters of administration. There's no authority until the court order issues. So in those circumstances, often the family will agree on the arrangements, somebody will pay it, and it's agreed by everyone that there will be a reimbursement from the estate. Once somebody is appointed by the court to act as the administrator, the funeral expenses will be reimbursed. It might be possible to provide a copy of the bill for the funeral arrangements to the bank where the deceased had their account and have it paid by the bank, but it's not a guarantee. If you're an executor and you take the bill into the bank, absolutely they will give you a check payable to the funeral home, and they will, and then you can pay it so that you don't have to pay up front, provided that there are sufficient funds in the account. But if you do not have a will, then the administrator isn't appointed, and they might say, you know what, we don't want to provide the check because there's nobody yet who has legal authority over the estate. But there are cases too where the family will fight over the arrangements. There's a case out of Ontario called Mwanga, which stands for the proposition that if there is no will, then the person who is most likely to be appointed as the administrator has the authority. So if it's a spouse, if it's a fight between the spouse and the mother, the spouse wins. Because under the legislation in Manitoba, the spouse under an Intestate Succession Act, where there's no will, is the sole beneficiary. She is the person who's entitled to apply for the letters of administration. There was a 2014, and again, these things come up all the time, there was a 2014 decision called Caddo and Caddo, again out of Ontario, where the person died. He had a wife, and she was distraught, and the funeral arrangements were made by her sister and her mother-in-law, and the understanding was that the husband was going to be buried in the family plot in Quebec. Once the wife recovered a little bit from her grief, she did not want him buried in the family plot in Quebec, so she took him back to Ontario. He was cremated. She took him back to Ontario and had him interred in Peterborough, which is where she lived. And then a few months later, she told her mother-in-law. I can't imagine this was a happy family in any event. So the mother sued, and she wanted the urn exhumed, and she wanted half of the ashes to be buried in the Quebec cemetery because that was what the agreement was. And so they had to go to court because the wife said no, and the court said the wife was the person who would apply for the it's letters of administration in Manitoba, the Ontario equivalent, and therefore she had the ability to make the decision about where it was to be buried, and she was under no obligation to provide any of the ashes. Now, the personal representative's ability to deal with the body after death might be affected by some pieces of legislation. So, for example, the Human Tissue Act is the legislation that deals with organ donation. And if you signed an organ donor donation before death, then that gives full authority to the appropriate people to take possession of the body and to act on the organ donation. And one of the things that I discovered in preparing for this yesterday is that we have an organ donation registry, which I was unaware of. And it's called signupforlife.ca, and you can sign up online, and then you are a registered organ donor. So if somebody has signed an organ donor card, then that would be sufficient. I mentioned that I put the organ donation in my healthcare directives so that the family is aware of it and the hospital is aware of it when somebody goes into the hospital. They could also check the website. Now the reality is that they will still consult with the family. And if the family decides to ignore my wishes to be an organ donor, then of course they're going to pay attention to that. But part of my job as the organ donor, would-be organ donor, is to now tell my family, I have signed up. It's registered, it's on the website. I am an organ donor, just so you know in advance. Don't be surprised if they come and approach you. The Fatality Inquiries Act also may give the medical examiner the right, the legal authority to have the body in advance, because there may have to be an autopsy done. And in the legislation, it sets out a whole bunch of conditions where an autopsy is mandatory. So in those circumstances, then the executor has no rights over the body until the medical examiner has finished its task. And then finally, it might also be affected by who owns the cemetery plot. The Cemeteries Act is the provincial legislation that deals with cemeteries, how they're owned, how they're regulated, how they have to operate, all the things that they have to do. And there's a section in there that talks about conveyance of the cemetery plot. And there was a Manitoba decision involving the Elmwood Cemetery that says the conveyance of the plot is a transfer of ownership. So whoever is on the cemetery records as owning the plot is the one who gets to say what's going to happen with the plot. So if somebody dies and they say, I want my ashes buried with my mother, and the mother's plot is owned by someone else, that person can say no. So that's where the personal representative, executor or administrator, might not be able to give any weight at all to the wishes of the deceased, which again is just a little reminder of why good family relationships are so important. Thank you very much.
Thank you, Cynthia. So what I was hoping is that the presentation would be chock full of just really practical advice, and I think Cynthia hit it out of the park. She took a topic that can be very general and kind of hard to grab hold of, and gave us some really, really practical direction on how to handle this area. So again, thank you very much, Cynthia. So just so you know, this presentation, Cynthia's last presentation was videotaped. It's going to be uploaded in the next little while to our website. We'll be submitting this one for compliance approval to do the same thing. So again, if you're on our distribution list for the emails, we'll be sure you're alerted once the presentation is done. I think this is one that's well worth taking a look at again and remind ourselves of some of the recommendations. I think one key one is just communication and making sure. I thought the idea of having that smaller sort of piece that's with the health card, Manitoba health card, is so practical. Because at that moment, people need that direction, right? Not some, in fact, I think our health care directive is in our safe. Not a good idea. Yeah, so I've got an action plan here after this presentation. So I think Cynthia will take a few questions. Cynthia, you have a few minutes for that. If you have not completed the little card for the draw, please make sure you do that. And as we're taking questions, Janelle, I think we'll go around collecting the draw cards. Make sure you complete the feedback form as well. We appreciate that feedback. You can leave it on the table when you leave or at the table on the way out. So again, thanks so much everyone for attending. If you need to sneak out, understand. If you want to stay for the draw, it's well worth it. $1,000? No, not $1,000. Something there. So, a few questions. Anyone have any questions for Cynthia?
Just a heads up. If you're going to ask me a question, it needs to be a general question, not my brother is stealing my mother blind, because nobody can use anything that I say today to say that tradition law is not allowed to represent the other side. So there's no conflict information here. But if you have some questions and can phrase it in a general way, I'd be happy to give it my best shot. Yes? Mm-hmm. And what about the healthcare directive? So the question is, when you've appointed somebody as the executor under will, or as an attorney and a power of attorney, or as a proxy and a healthcare directive, do they have to be in the province of Manitoba? And the answer really is, from a practical perspective, it depends. For the executor, whose job arises from the moment of your passing, they can live in any place in Canada, and they will not be required to post bonds and sureties. They'll be able to deal with the estate. We often will have executors who live in other provinces or in the territories. You deal with it by email, by FedExing the original documents as possible to deal with it. So it adds a little bit of time and money to the administration of the estate when they're away, but they don't have to be here. You want to try, if at all possible, to avoid having foreign executors, which in this circumstance means anybody outside of Canada. So the children who live down in San Diego, not necessarily a great choice, because there's all kinds of potential tax issues that arise when you have a foreign executor. For a power of attorney, very often the person who's the power of attorney is also the proxy, and so an issue there is, just from sheer practical perspective, is will the person be available to help when you need them? If the person is incompetent and they're in a care home and it's just a matter of dealing with money, then probably being out of the province is not too bad. But what happens if the person is in that gray area where they have been managing their own affairs, they're not yet incompetent, but they need some help? That's difficult to do if you're in another province. And then from a healthcare directive perspective too, if there's a medical crisis, how easy is it going to be for the person to be available in order to make the medical decision? It might be that it can be done over the phone, but we know what it's like to try and get a hold of the doctor when you're standing in the hallway, never mind trying to reach them on the phone. So certainly local is most practical from a power of attorney and healthcare directive perspective, but your family may not allow that. They may not be here. And so then it's a discussion about how exactly would that work.
Judy, I think you had a question. Okay.
Yeah.
Another question?
Yes. Is embalming mandatory?
Pardon me?
Is embalming mandatory, depending on the situation?
So the question is embalming mandatory? I did not look at the legislation on this specific issue, but speaking from a personal perspective, I would say no. I am Jewish, and we do not embalm. And the Chesed Shalemis on Main Street is the funeral home where our bodies are prepared, and there is no embalming. So based on that personal perspective, I would say no, it's not mandatory.
Take one more question. One more? Yeah.
Just for a clarifying point, you have your short or long form of the health directive, and you have the proxy. Now, let's say the ambulance takes me to the hospital and they're in my fridge, so it's short health form directive. They have the obligation immediately, or is it as soon as possible, contact the proxy, and does the proxy, can they override what's in the health directive, or at least guide it?
Okay, you've asked multiple questions there. So first off, was when is the hospital obligated to contact the proxy? So if you have, again, I'd have to approach this from a practical perspective and not necessarily from a legal perspective. The reality is that you could be at home with a terminal illness. You may have a do not resuscitate order, but if you're dying at home, there's a particular kind of healthcare directive that they want people to sign so that it's a form that all the ambulance attendants understand and know. So they know very much that they're not supposed to do anything at the scene, and it's a matter of simply transporting for purposes of dying in the hospital. But if you don't have that and it's an emergency, they're not looking for your healthcare directive. They're not standing over your body trying to figure out what it is that you want. Their obligation at that point is to stabilize you as best you can and then get you to the hospital. So once you're stabilized, My thinking is that then they are looking for the healthcare directive. They're looking at that. If you have the ERIC kit, then they're looking who is it that they're supposed to call. They're making phone numbers, but they're first, it's my understanding that what they will do first is stabilize. They're not standing and looking at the healthcare directive and deciding whether or not they have the authority to do it. But once you're stabilized, then they're looking for who is the person that we're supposed to talk to about making medical decisions. Was there another part of that question that I missed?
That more or less covers it. If it's more of the matter of, let's say I put in do not resuscitate, are they going to immediately then do nothing, or are they still going to try to stabilize?
They will still try and stabilize unless you've got a terminal illness. And I am told that there is a particular kind of palliative care healthcare directive that you would sign, that they would ask you to sign, so that everybody who is dealing with you knows that there's a do not resuscitate order. The important thing, if somebody's going into palliative care and they're being asked to sign one of those healthcare directives, so that it is obvious and so that we don't have situations where somebody is being stabilized when they in fact want to die, is that you have to make sure that that palliative care healthcare directive does not revoke your previous healthcare directive, or that if it has a proxy provision, that the proxy provision in the palliative care health directive matches your other healthcare directive. So there's a little bit of work that would have to be done at the time that the palliative care healthcare directive was being signed. But at that point, you're not in crisis, right? At that point, you're going into palliative care, and the care regime is being set up to allow you to die as you wish. So you just have to make sure that the documents match, because we want to avoid the situation where there's two different people who are named. And whether or not somebody can override your decision, yes. Because if at a point where I am not able to make a decision, it's up to my proxy to make the decision that they believe that is right for me. Which is another reason why you want to make sure that your proxy understands your wishes and says, yes, I will do this. I remember someone that I met once who only had one child, and the child says, I will never agree to sign to turn off the machine. So the discussion with the client was, then is that who you want to be your proxy? Because they are telling you in advance that they will not do what you want. Is that person the best for the proxy? I also I was aware of another case where in that particular circumstance, the fellow had 5 children, and all 5 of them were the proxies, which is sort of counterproductive. The whole idea is to make somebody the one responsible, so that a decision can be made in crisis, and crisis decisions by committee are not the best thing. But in that circumstance, all 5 children were named as the proxies, and he went into a critical mode, and 4 of the children said, treat him, and 1 of the children said, don't treat him. He was treated, he recovered, he signed a new healthcare directive to take out that child. Thank you.
Awesome. So takeaway, if you're over that arbitrary line of 70, you better get your ERIC kit if you don't have one yet, and there's a fire station not too far away, so you make that part of your destination on the way home. Well, I hope you enjoyed the presentation on healthcare directives. I think Cynthia did a fantastic job of giving us an overview and some very practical ideas on how to plan in this area. During the presentation, or at the beginning of it, we talked about the wealth planning process that we put together called the gap analysis. As a wealth planning practice, we think it's really important for clients to have clarity in their overall financial plan. Healthcare directives is just one piece, but that includes pulling together the various functional areas. It could be estate planning, tax planning, business succession planning, retirement income planning, investment planning are just a few examples. Are you beginning to think about that area? Do you want clarity on whether or not you're tracking in the right direction? Then you should explore the gap analysis. It's a complimentary service, and if you'd like to engage in a conversation, to reach out to us to talk about whether the gap analysis is something you should take advantage of, we'd love to have the conversation. Our direct line at the office is 204-977-8022. Feel free to visit our website at seanhumphreys.com, and there's a way to reach out to us as well there, and all of our contact information information is there as well. So I hope you enjoyed the presentation, and again, when you reach out to us, if you're not on our email distribution list, make sure you're on the list so that as we post new content and new material, we can alert you to the fact that that material is now ready for your viewing. Anyway, you take care and all the best in your wealth planning journey.